All right, we're going to test this out. Recording in a new location with different equipment. And I'm sure it's going to be fine. But this is the Section 2 podcast for civil litigation and administrative law. Starting first with civil litigation and the high points from civil litigation. And again, these two courses, the topics sort of overlap, thankfully, this week. That won't always be the case, but it will this week. So it's going to, as we said, a lot of times we build similar skills for different substantive areas of the law. In civil litigation, the investigation is generally the gathering of facts, more specifically the gathering of facts admissible in evidence. Now, investigation is a term applied to the detective role of litigation. You aren't a detective and you don't have a badge and you can't compel somebody to talk to you. And if you've had my evidence class or will take my evidence class, you will learn that police aren't really supposed to compel people to talk to them, but they do have a little bit more leeway than you would as my paralegal, legal assistant, or young associate going out to talk to someone in an investigation. That doesn't mean that you aren't doing those things. To understand your role in the investigation, you have to understand the term cause of action. The legal claim that if proven, and if there's no successful defenses raised, would be sufficient to lead to a judgment. And what you're investigating is the facts that support that cause of action, that legal claim, the elements of that legal claim. If you've had criminal law, you know that there are elements to criminal offenses. There are elements to civil offenses, to civil claims, to even claims of contract breach. Whatever we do on the civil side of the courtroom, there are elements to those things we must prove, just like you have to prove the elements of a battery in a criminal battery case on the criminal side of the courtroom. The process for getting a litigation client to your office and items for the client to bring to that initial interview are important for you to be aware of and understand. At some point, if you work in litigation, in particular the plaintiff's side of litigation, prosecuting a civil case that would end up in litigation or at the courthouse in a courtroom, you'll be involved with an initial meeting with the client and maybe subsequent meetings with the client. So some of the things that you'll see as being the documents that you would want the client to bring to that initial discussion, that initial interview, their medical bills if they have any, their medical records if they have any, insurance information, accident reports. If we're talking about vehicle accidents, which a lot of times we are, that's often confused with the police report. In Illinois, an accident report is different than a police report. An accident report doesn't necessarily require a police officer, although police officers do create accident reports. Any relevant photographs, any relevant correspondence from insurance companies, from the other party, from lawyers, pay records if lost wages would be a claim, invoices or estimates as to vehicle damage, and we'll talk about this at other junctures, but some of you may know from personal experience that your vehicle gets repaired long before your body or your medical issues are even sometimes fully understood and diagnosed. And then any catch-all request, other relevant documents in your potential client, and I use the term potential client's possession because at this point we haven't decided if the person will be our client. As some brief interviewing tips for the first time you meet and interview a potential client. We always want to avoid leading questions, and you've heard me talk about leading questions already. this semester, but leading questions are those questions where the person's sort of pinned into a corner of being only able to answer yes or no. What we want in this situation is for the person to tell this story, narrate their story, what it is that they've presented or want to present to us, what happened in their own words. Sometimes that leads us to tough questions. Had you been drinking? Were you wearing your glasses? Did you have any other substance that might hinder your ability to drive a vehicle? Had you just been to the dispensary and then taken a couple of the 50 milligram gummies that you've told us that you use to sleep at night? We typically work from the general to the specific, so we get a broad picture of what occurred, and then we can ask specific questions or more specific questions to get the details. So initially, let them narrate and get the broad picture, and then think about what other things you might want to ask. And we obtain the background information regarding the client's sources for the information they do provide. Again, these are potential clients. We haven't decided if we're going to take the case. And when I say we, I mean the lawyer who's going to be responsible for handling the case hasn't decided. There's 3 reasons we perform these tasks at the earliest possible date, and that would be as close as possible to when the civil harm occurred to the client. First, facts might, in a sense, change. Witnesses' recollections fade. Important documents might be destroyed or lost. Information may become compromised or lost. It may take significantly longer to complete the investigatory tasks than anticipated. By starting early, the impact of delays is minimized. Once facts become known, they often tend to raise new questions in other areas, necessitating further inquiry and investigation. Now, there's 4 cardinal rules of investigation that you will come across time and time again. 1, you perform your investigatory task at the earliest possible date. We know this in all aspects of investigating, civil or criminal, right? If you've taken some of my criminal law and evidence-based courses, you know that I push the show In the First 48, which focuses on the pretty much scientific fact that if you really get on your investigation in that first 48 hours, if you have a good investigation and you find as much evidence as possible in that first 48 hours, you're more likely than not to find the person who committed the crime. In that show, it's homicide, and then also get a conviction. And if you can't get a decent amount of information and evidence in that first 48 hours, the more likely it is that things are going to remain open. Same holds true in civil cases. You have to have accountability, accept responsibility for completing the investigatory tasks yourself, things you've been asked to do. You do those things. You look the people in the eye. You have the conversations. You do everything you're supposed to do by the timeline that you've agreed to or the lawyer has dictated that the lawyer wants you to complete those tasks by. Sometimes you have to be creative in your approach, but you always want to be thorough. You always want to be thorough. And if you remember in the duty of competence, thoroughness is something that we're expected to do in the law. Now, for legal assistants or paralegals interviewing potential clients, you always want to identify yourself as a paralegal and explain what that means. Now, what that does is, in that explanation, you're setting the ground rules that I can't give you legal advice, because invariably, especially if it's a client, and sometimes if it's not the client, people will ask you for your legal opinion or advice, and you can't give that legal opinion or advice until you go to law school and pass the bar exam and become the lawyer. That's a blessing. That's a good thing. That's an awesome thing, because it allows you to just get the investigation done, and you can just divert that conversation from talking about things that you're not legally able to talk about. Now, you should keep the question, write the question down, and take it to the lawyer. And you may, at the lawyer's direction, be tasked with going back to that client or potential client and giving whatever the lawyer tells you to give them as far as advice or answer to the question. But in that, you have to figure out a way to develop a rapport. Now, developing a rapport with somebody, from my particular preference and experience, is to be available to them, look them in the eye, be sure that they believe that you're listening to them, be sure that they understand that you're trying to hear what they are saying. And you do that with eye contact and patience, and not a focus on the questions you want to ask, but more a focus on what they're trying to tell you. And then, as we said, start broad and come back and ask your questions after you've developed that rapport. You need to work from an outline or a checklist. I always have, if I'm in that situation, an outline of the things that I expect to accomplish in that interview. Regardless of who that person is, I want to know, I want to have a general idea of what it is I'm seeking to find out. And, again, the particular cause of action. It's a personal injury case, it's a contract dispute, property damage dispute, whatever it might be. That general expectation, or the general thing that you're seeking to investigate. So you should also be aware of what the elements are. You should be aware of what it is you're going to be looking for out of this person in the interview, but also in the facts that you're going to come across as you go through the case. Now, you can vary in order on your checklist, but make sure you cover all the items. And again, start with broad questions. Allow the client to tell his or her own story before you begin. I usually start with, and you'll see this when we get into interviews a little more, but I usually start with the background, the person's background, general easy stuff that everybody gets asked, about who they are, where they live, when they were born, their family status, their work status, the contact information, general information. And from there, you can get into what happened. You want to take careful notes. Taking careful notes is not writing down word for word what they say. If you can record it, if the person allows you to record it, then record it. But I don't think that's always necessary unless you don't think you're going to be able to find the person again. And recording usually occurs with witnesses, not necessarily with clients. Active listening, again, is what I was talking about, where you're looking at the person, you're watching what they say, how they say it. You're really observing and taking in what they're telling you. You're not just letting it go in your ears and settle somewhere in your brain. You're not thinking about the next question. You're actively listening to and seeing what they say, how they say it, and sensing any things you need to sense, at the same time really focusing on what it is that they're telling you. Now, once you hear all their story and you have all the information that your checklist says that you should have, you want to take a beat. You want to take a deep breath. You want to say, I just need a minute here. Review their story, their statements more than once. You may have misunderstood the person's meaning on something. They may have misspoken. If there's anything you need to clarify, get those clarifications. The time to get the facts straight is before the interview is terminated. And that's true with witnesses as much as potential clients. Now, if the interview with the client goes well, and the lawyer decides to take the case, you're probably going to be tasked to go out and find and seek interviews with witnesses, especially if it's an occurrence of like an injury or property damage. So who are the sources for the potential or possible witnesses? The client. The client should be informed about the factual areas on which witnesses might be needed, and they may know who was around and observed things. They may not know the person exactly or the person's name. It may be something like, well, this happened in the intersection in front of Starbucks, and I go to Starbucks every morning, and the person who I believe is the manager was out in the front and saw the accident and came over and offered to any help or to call the police because they recognized me. That's a potential witness. Relevant documents, police reports, medical records, news articles, anything that may list people who saw what occurred. And then sometimes once you find those initial witnesses, the witnesses themselves are good sources for other witnesses. There may be people that you didn't know about before that they know about who may have seen what happened. And then the discovery process that we'll get in later in civil litigation, the other side, the other parties in the case may have ideas about potential witnesses, people who knew what happened or have some sort of testimony about the occurrence. Now, some factors to consider when interviewing witnesses. They're the same as for the client interview. We want to follow a checklist. I want to have a checklist for the same reasons I stated before. I just want to have an outline of what I need to get from this person, and I start with those basics. I start with their name, address, phone number, date of birth, their work background, their educational history, their family history. Make sure I'll be able to find them in the future if I need to find them in the future. I want to take careful notes. But again, notes. I'm not writing down every word that they say. I do usually prefer to have that statement from a witness recorded if they'll allow it, and I'll explain to them that I'm seeking to record your statement so I get it accurately, and then once I have the recorded statement, I will have it transcribed and present it to you so you can both hear and see what was said, and then I'd probably ask you to sign off on it, and I may not need to call you again for anything else. I'm always straight up with them that it may require that you need to have your deposition taken. If the case goes to trial, you might get called to trial, but I'll work with you to make it as convenient as possible. And I also work with them to make it as convenient as possible in that initial interview. You do it at their time when they're not going to miss work, at a place and time that's convenient to them. If it's of a accident scene, I prefer to meet them close to the accident scene so I can see where they were and what they observed and ask any relevant questions there. We identify the foundation for the testimony, so their role and their ability to see and to provide the testimony or the things that they say they had witnessed. We review the facts that the witness has shared to verify accuracy. If something doesn't seem like it could be accurate, I don't argue with these people. I just write down what they say. We come back and form our opinions later. But if it's clear that from where they tell you that they're standing, that they couldn't see the part of the intersection that the accident was in, we do not challenge them. Okay, we don't argue with them. We just take down what they're telling us, and then we note our observations, our concerns, our opinions, and you go and talk to the lawyer about that. Again, you go from the generalized questions to the more focused follow-up. Unique for the witness, this isn't your client. You have no expectation of confidentiality or any other reason to cooperate with them or them to cooperate with you or to trust you. So it's kind of a precarious situation to some degree. If they ask you for confidentiality on what they're going to tell you, you got to tell them, I can't really offer that. I don't represent you, and you're expected to tell the truth. If you're called to testify at a deposition or in trial, then you're going to be testifying under oath. So I'm just trying to find out the truth now. The witness may be reluctant if they have useful information and they're reluctant. Appeal to the sense of justice. Now, people can be reluctant for various reasons. In today's society, we get a lot of, I just don't want to get involved. And so then you really have to appeal to their sense of justice. I usually try to explain it. That's fine, but we believe you do know something. And so, I want to work with you. If I find out what you know now, I might not have to inconvenience you in the future, but I'd like to know what you know now. But then again, witnesses may have some interest bias motive for not wanting to testify or for their testimony or potential testimony anyway. And you got to ferret that out in this process. If they're hostile and they indicate they're not going to participate again, that's when you have to resort, and I would let the lawyer handle that, to talking about subpoenas for deposition, and that we don't want things to go to that level. Then we'll try not to inconvenience them, but we may not have a choice if you're not going to cooperate. But we have to be as flexible as possible until that point. And in most cases, if you're flexible, in most cases, if you treat people how you'd like to be treated, they will come around. Unique to the witness interview, I want to get to the potentially neutral witnesses first. I don't share information about the case the witness doesn't need to know. If they ask me what happened, my client get injured or whatever, I might say, yeah, my client's been injured. And other than that, I don't give them the details and just say that I'm not prepared to talk to them about that at the time. Time may be limited, so we want to ask important questions right away. If the witness is represented by an attorney for this particular case, I have to communicate through that attorney and not with the witness directly. That's probably only going to happen if the witness is, an employee of one of the parties, something like that. Some people will try to claim that they're represented by a lawyer and they don't want to talk to you. I guess in that situation, and I don't recall that it ever happened, but I guess what I would do is contact that lawyer and say, hey, I'm trying to make it easy on your person. If you represent them, I don't know what you represent them in, but you don't represent them in this case. And it'd be a lot easier if they just talk to me now. Maybe I don't have to depose them. And if I do depose them in the cooperative, I'm going to work with them to make it as convenient as possible. Same if we have to go to trial. And the lawyer will understand that, and that's what they'll advise their client to do. But they're not really getting protection and you being able to claim attorney-client privilege if they're not a party and they're not a agent of a party. Like I said, also unique to witnesses' interviews, I like to obtain a signed statement if their testimony appears to be helpful. And possibly even if it's not, in order to just kind of pin them down as to the details of what they said they observed closer to the time of the incident. And we always want to obtain address information, make sure that it's up to date, if they have any plans to move, etc., in the event that a subpoena is necessary for deposition. Now, it's much easier to track people down today than it was, say, 20 years ago. But that's just something you want to be aware of. You also may be called to help find expert witnesses. Expert witnesses, that's somebody with scientific, technical, or some other specialized knowledge who's going to assist the trier of fact, the judge or jury, in understanding evidence or to determine a fact or issue. There's somebody who's qualified by knowledge, skill, experience, training, or education, and they can testify in the form of an opinion. They didn't see what happened. they aren't able to say the vehicle appeared to be traveling at a rate of speed higher than the speed limit and the other vehicles on the roadway, but they probably, by their education and their skill and their training, are able to calculate based on skid marks and crash data how fast the vehicle that was at fault was traveling at the time of the accident. Where an expert opinion or witness testifies to an opinion based on a new or novel scientific methodology or principle, the proponent of the opinion has the burden of showing that methodology or scientific principle is based on sufficiently established and generally accepted elements in that field. I provided reference to Illinois Rule 702, Rule of Evidence 702. You should go and read that rule. That deals with testimony by experts. But what you need to do when retaining an expert is you need to be familiar with yourself with that particular field, that particular thing. And sometimes you can come across something that you need an expert for. It could be a medical condition. It can be some sort of instrument or machine or a vehicle, something that was part of the accident that you need to understand. I've had expert witnesses on road construction cases where someone was killed because of how the road construction was set up. I've had expert witnesses on medical conditions, reflex sympathetic dystrophy, which I had never heard of, and had to go to the medical library at the University of Illinois College of Medicine and learn all about reflex sympathetic dystrophy, and then find an expert in that field. I had a case one time where it was alleged that my client misapplied fertilizer on some version of hybrid corn that a guy was trying to develop in Tazewell County, and I had to learn all about corn and autopsies of corn and hire somebody an agronomist who was an expert in corn. Lots of different things. But you have to familiarize yourself with the relevant field. Now, it's much easier to do that if you use recognized resources, not Reddit. Recognized resources, although Reddit might be able to lead you to some of those discussions, can lead you to some qualified stuff. But you have an ability to familiarize yourself with those relevant fields. I mean, any of the things I listed off from back in the day, in cases that I handled, you can find those things by just using good old-fashioned Google. Once you familiarize yourself, you can start contacting obvious experts such as treating physicians who've already been consulted by the client. You can contact companies that can help you find people, university departments in the relevant field. You can review classified sections of legal publications. You can ask other lawyers in town or in your firm. And then once you find that potential expert, you want to be sure to obtain their resume so that you can assure that the person has their qualifications. You can also find out all about these people these days online. We used to try to figure out if they were plaintiff-oriented or defense-oriented and all of that. You can do all of this fairly easily. Finally, and possibly the most important bit of advice for a legal assistant, lawyer, or anyone else involved in investigation in a civil claim or a criminal case for that matter is the point that I raised, I believe, to a degree last week, and that's when I was discussing admissible or inadmissible. As long as you gather evidence, speak to potential witnesses, and do the things up front, transparently, legally, and ethically. For instance, telling potential witnesses you're a legal assistant for Tom Higgins, the lawyer, and for the plaintiff in the case. Go gather all potential evidence, like a giant shop vac. You gather it all. And then we sort it out with your supervising lawyer's input and approval, and you don't worry or get sidetracked about admissibility or what evidence is more valuable than other evidence. You remember that inadmissible evidence may be admissible for another purpose, and it may lead to admissible evidence. And as long as it wasn't acquired in violation of someone's rights or by way of fraud or deceit, it should end up in your shop vac. And then we dump the shop vac out and we sort it out. And eventually we get to the admissible stuff and we decide if something's inadmissible or if we want to just go ahead and let the judge determine. Because remember, it's the court who determines whether it's inadmissible. Let's shift real quick to administrative law. The topics for this section are the processes and tools for methods an agency may use to initiate an inquiry to a concern or issue with a particular party, and provides the known mechanisms for cooperation, reporting, and compliance from the party. By their nature, we expect agencies to keep a reasonable, watchful eye on the businesses or sectors of society that they are created to regulate. Agencies make decisions after information is gathered during agency investigations. And we just talked about investigations on the civil side. Some of the agency process can be informal. Some of it's formal, up to the decision, but the decision is reached with a specified process and protections. The basis of an agency's jurisdiction is established in the enabling statute. These statutes allow the agency to establish rules and regulations that dictate that businesses regulated by the agency must keep certain records. Those records can be requested, reviewed, and lead to inspections, investigations by the agency, or voluntary compliance and submission to reviews and certain remedial action. Agencies typically get the businesses by way of business licenses granted to that business for the purpose that the agency regulates or controls. A license is permission granted to an agency to engage in the activities such as driving or running a business. And the licenses comply with standards and regulations of the agencies. Licenses are typically granted after an application has been submitted and an inspection is done, and the agencies determined that you are capable of and able to perform the business or do the things that the agency has been set up to regulate. If we're concerned about a business client and protections from unreasonable collection of information by way of the Fourth and Fifth Amendments, the Fourth Amendment protects clients from improper searches and inspections, and each Fourth Amendment analysis always revolves on whether or not the search, regardless of the setting, was reasonable under those circumstances. The cases tell us that judicial review requires standing, rightness, exhaustion, and primary jurisdiction. In judicial review, courts examine and review agency decisions. Both the laws and the factual conclusions made by the agency can be reviewed. There's no new evidence or testimony, simply arguments and the record from the agency or body that decided the matter and prompted this administrative review. And this is what we call the appeal in an agency. Agency review is the first level of appeal. To receive a judicial review, an appellant must follow standards and requirements. The agency creating the statute, the Enabling Act that creates the agency, and the Administrative Procedures Act, and in Illinois we have the Illinois Administrative Procedures Act, provide for judicial review of that decision. And judicial review affects both the person seeking the appeal and the agency itself. If an agency statute does not allow for judicial review, the client may appeal to the courts through the Administrative Procedures Act. And when I say that, I mean the Illinois Administrative Procedures Act as well as the Federal Act. But always remember, judicial review is restricted to the agency record, as is the case with any other appeal. Now, for a long time, a couple decades, I sat as the administrative hearing officer in administrative proceedings on municipal ordinances that were brought by way of a process set up under the Illinois Administrative Procedures Act. If a city or a defendant in a case wished to appeal my ruling, they would appeal to the circuit court applicable to where I issued the decision. So if I was hearing cases in Tazewell County, they go to the circuit court of Tazewell County, and Peoria County, it would be Peoria County. That statute has a built-in process to seek a rehearing, but that rehearing must be requested within 35 days or the decision becomes final and ripe for appeal. The party requests the review in the circuit court in which the decision was issued. The court serves as the first level of appeal, reviewing the record, not hearing any testimony, not entertaining any new evidence, but reviewing only the record of what happened prior to the appeal. From that point, appeals go to the appropriate Illinois appellate court district, and then possibly the Supreme Court. It's the same path that we see for other Illinois administrative matters. We'll talk about work comp later in the semester in administrative law, and work comp cases go through the commission, and then once that process is exhausted, they go to the circuit court and then to the appellate court if it gets that high. Again, in general, for judicial review, a court examines and reviews the administrative decision. Both the laws and factual conclusions made by the agency or its hearing officer may be reviewed. No new evidence or testimony is allowed to be presented. This is just like any other appeal. And the reviewing court hears arguments and reviews the record from the case that prompted the administrative review. And that is what we call this type of appeal, administrative review. The only other thing I would add is in the agency investigations, I mentioned that it was oftentimes informal. In the agency settings, as opposed to the civil litigation, say, or courthouse-based settings, in general, those processes, they are really set up to get compliance, to get cooperation, to get, whoever's violating whatever the agency is set up to regulate, doing things improperly or whatever, alleged to be doing things improperly. It's to set up a opportunity for those parties to come into compliance. And so there is a lot of informal parts to it. There is some informal investigation. For instance, a lot of times when somebody makes a complaint, the agency sends somebody out to that particular party, and while investigating the complaint, a dialogue gets started. It doesn't always require, for instance, a warrant or some formal method of getting on the property or investigating whatever the allegations may be. And then as part of that initial discussion, which you could call an investigation because that's what it is, they come to a resolution and they say, hey, I know I'm supposed to be doing X, Y, and Z, but right now we're a little short on cash and we'd like to get that rectified. And once we get it rectified, we'll get it, fixed, up and running. We'll stop doing whatever we're doing and we'll get it fixed. And then the agency employee will say, well, when can you get that done? I can get it done in 2 weeks. Okay, well then let's talk about it in 2 weeks. They come back in 2 weeks. If it's done, there's never anything formal that's written up. Or maybe the agency has a warning process, and then the warning process is nothing that's going to go on somebody's record. If the work's done, the things are rectified, it goes away. So the focus is compliance. Ideally, you have compliance before you ever get to the point where someone is harmed, another property owner's harmed, the public's harmed by somebody dumping things they shouldn't have dumped that caused problems with water or whatever you have. Okay? Keep in mind those differences. Those are the high points for civil litigation and administrative law for Section 2. If you need me, you know where to find me.